happens when a personal law allows something that is specifically prohibited by several provisions of the criminal law, particularly those which are meant to protect children? That is a question that the NCPCR, that is the National Commission for Protection of Child Rights, has asked the Supreme Court to look into in a case coming out of the state of Punjab, where a 16-year-old girl has been allowed to get married and live with a man of her own choice. The Solicitor General, appearing before the bench headed by Justice S.K. Kaul and A.S. Oka, has argued today that this case raises a very serious question of law, particularly of the interpretation and the impact of Section 375 of the IPC, which basically says that sexual relationship with even a wife who is under 18 years of age is in fact going to be counted as rape, plus the provisions of POCSO and the Prohibition of Child Marriage Act. What happens when these acts and laws clash with the Islamic law that allows a woman to get married after attaining the age of puberty? The court has noted that this question is an important one. This is an important aspect of the law which needs to be considered, and has appointed Advocate Rajshekhar Rao as the amicus curiae to assist the court in this matter. At the same time, Solicitor General Tushar Mehta, who was appearing before the court on behalf of the NCPCR, has clarified that this issue that has been raised before the court is not targeting this girl in question, nor have the protection orders for this girl's safety that was passed by the High Court. Those also have not been challenged by the NCPCR. But now on November 7th, the court will consider this larger issue of the interaction between the personal law and the criminal law, and how they will impact the choices, privacy, dignity and the safety of children in India. In New Delhi, this is Aneesha Mathur for India Today.